If this is your first time being involved with the juvenile justice system, you may be overwhelmed and you may have a lot of questions about what to expect during the process. That's completely normal. During this video, we'll talk about all the steps along the way of what to expect during the life of a case in the juvenile system. So the very first thing that's going to happen to bring your kid into the juvenile justice system is that someone's going to make a complaint about something that your child did. That complaint may be something that happened at school, in which case the administration at the school would probably be notified first. They may begin a small type of investigation where they talk to other kids in the school or staff from the school or your child. Probably if this happens at school, the very first thing that's going to happen is that the parent or guardian will get notification of a school suspension or the potential of a school expulsion. The parent or guardian will get notification of a hearing date, and then that hearing will occur, and at the end of that hearing you'll know if your child is going to be suspended or expelled because of their behavior. If your child is reported to have done something that's not at school, the school may still be notified, and the same things may happen with the school's investigation. They may still have the hearing to determine if your child is going to be suspended or expelled, but also the police will get involved. Once the police get involved, they'll do their own investigation. The police will get involved if this happens at school too, but either way, once the police get involved, they start their own track toward the juvenile justice system, where so far what's happened with the school is on a separate track just involving school processes. But once we get on the track toward the juvenile justice system, the police will do an investigation, they'll talk to the people that they need to talk to, they'll gather what evidence they need to gather. They may want to speak with your child or they may not. It really depends on what the accusation is. This is what we typically call the investigation phase of the process. This is because this is when the police do their investigation. If we represent a child as early as this investigation phase, then we can step in and have conversations with the investigators, the police, the detective, whoever, and if there's any information or any evidence that we believe would be helpful to your child's case, we can provide that information to them and potentially change the course of the process altogether. Even if we don't have evidence or information to provide to the police, sometimes just having that communication with the police department helps us have answers to provide to the parent or guardian so that you can have more information along the way. Once the police department is done with their investigation, if they want to move forward with the case, they will refer the case to the Juvenile Services Department. At the Juvenile Services Department, there's a section of their probation department who only does intake. So an intake officer with the Juvenile Services Department would get that file from the police department. They would review the reports and maybe written interviews. They would review the basics of what the allegations are, and that intake officer would want to bring the child and the family and the attorney, if I represent your child this early, they would want to bring us into the office to gather some more information about your child. So they would want to know basic life history of your child and not so much specifics about what the allegations are. So at this point, they're really just trying to build a file. So they'll ask all kinds of things like your child's medical history, their education history, mental health history, if there is any, disciplinary history, if there is any. They'll also ask questions like who all lives in your household, how do you discipline your child, how do you reward your child, different questions like that, so that they've got a full picture of who the child is instead of just only knowing them for this one incident that they're there for. This is beneficial because if it's later determined that the child needs any services or any help or any programs, when we have this full picture of who the child is, we've got a better idea of what services or what programs will best benefit the child, because everyone's goal at this point is to prevent the child from ever coming back into the juvenile justice system. Once the Juvenile Services Department is done with their intake and their gathering of information about the child, occasionally they have the opportunity to close the case there. It could be possible if we have information to provide to the Juvenile Services Department about things that the family is doing on their own. Sometimes the family will take steps that early on to get the child into counseling, for example, or get the child into a treatment program if they need it, or to get the child some other services to where the Juvenile Justice Department doesn't really have anything additional they can offer the child at this point. This really is an option for mainly low-level like misdemeanor offenses, but it is a possibility in some of these cases. If we have the type of case where the Juvenile Services Department is not able to close out the file after the intake, then the department refers the case to the prosecutor's office. So that means that the file with the police investigation and with the juvenile service officer intake information All of that now goes to the district attorney's office. There, a prosecutor will get the case, and the prosecutor will review everything in the file as well. At this point, when we're talking about the Juvenile Services Department and the prosecutor first getting their hands on the case, this is what we typically call the pre-filing stage of the case. This means that no official charges have been filed yet, but it also means the investigation from the police department is over. So we're in that kind of middle period where we're waiting for a prosecutor to make a decision one way or the other. At this stage, as the attorney, I would immediately begin speaking with the prosecutor to find out if there's anything that we can do, anything we can provide, or any other information we can give them that would help them understand the context or help them understand what happened better, so that they can make the appropriate decision. If the prosecutor reviews the file, they review all the information from the investigation as well as the intake information, and the prosecutor decides that formal charges do need to be filed, the prosecutor will draft what's called a petition, and that will outline exactly what it is that they're charging the child with, what the allegations are. That formal paperwork gets filed within the court, and a copy gets sent to the parent or guardian and the child as well, so that everyone knows exactly what it is that the child is charged with. After the petition is filed, the court will have been notified, and the court will start scheduling court hearings. This is where we go to court, and as an attorney, I'll be talking with the prosecutor's office about the potential for negotiations. Oftentimes, juvenile cases are able to be resolved through negotiations or through a plea, as we often call it. It is very rare for a juvenile case to actually end up at the trial stage of a case. So when we go to court, we may go to court one time, we may go to court many times. It really depends on kind of how successful we are at resolving the case early on, or it may be because the court needs additional information that we don't have yet. Sometimes the court wants a psychological evaluation done. Sometimes the court wants different kinds of evaluations or different kinds of information that we just don't have at the early court hearings, and it takes some time to get those. Or sometimes the prosecutors are waiting for evidence. Maybe there's something that the police didn't gather in their investigation, but the prosecutor believes would be helpful to the case, helpful for them to just understand the context of the child's life, the circumstances of the allegations, whatever it may be. The prosecutor has the ability to try to subpoena those records, and sometimes that takes time. So it's not uncommon for a case to not be resolved at that very first initial hearing. Sometimes cases do have to go to court multiple times, and that's perfectly normal. This is what we typically call the pre-trial stage of a case. This means that we've not decided the case needs to be tried before a jury or a judge. This just means we're in that space where we're trying to see if we can agree, trying to see if we can negotiate a successful outcome. If after negotiations and after however many court hearings we need to have, if we're not able to reach negotiation or reach a plea agreement, then oftentimes the case will have to go to trial. And what a trial is, that would mean that the prosecutors would have to prove all of the allegations that they've brought against the child. That means their charges, they would have to prove those. We've talked in other videos about what trial looks like, whether it could be before a judge or it could be before a jury. But the important thing to remember is that at the trial, the prosecutor would have to prove what they've alleged the child did. At a trial, we also have the ability to provide any information that we think is helpful, to provide maybe the answer to why a child did something, or that a child didn't actually do what it is they're accused of, if that's the case. If at the end of a trial, either the judge or the jury believes that the child did do what they're accused of, then the child would be adjudicated delinquent, which is the juvenile language for being found guilty, as we commonly call it. After the adjudication of delinquency, then the case would move on to the disposition phase, which is what we typically call punishment in adult language. Again, as we've talked about before, the punishment phase or the disposition could be before a judge or a jury. At that point, evidence will be provided by both sides to help determine what kind of resolution this case needs, what kind of disposition this child should have. If at the end of the trial, the judge or the jury doesn't believe the child committed the acts that they're alleged to have committed, or the judge or the jury doesn't believe that the child broke the law, they will find the allegations not true, which is similar to what we typically call not guilty. And at that point, the case does not move on to disposition. Instead, the child just goes home, and there's no supervision, there's no probation, there's no jail time, nothing like that. It's the same as a not guilty in the adult world. So at that point, the case is over and resolved. Thank you for watching. If you have any questions or comments, please leave them below, or you can find us at varghesestexas.com.